Yes, Mr. Pitcher.
My lady, I appear for the first appellant, Stephen Stubbs. My learned friend, Mr. Richard Thomas, appears for the second appellant, Andrew Davis. My learned friend, Ben Cooper, appears for the third appellant, Clinton Evans, with Amanda Cliff Matthews. And my learned friend, Peter Knox, leads my learned friend, Mr. Tom Poole, for the Crown. My lady, I hope the court has both the case and our reply.
And a few other bits and pieces of paper as well.
My lady, I apologise. I hope they are of assistance. The note number 1 raised the issue of section 66 and whether it was providing information to the shorthand writer or giving evidence to the court. My lady, and the note number 2 dealt with the question of whether there was in any event a power under common law.
Note 2?
Yeah. It was emailed through on Friday, I understand, but we do have it, my lady. We will provide
I'm not sure I've got a copy of Note 2, nor has Lord Lloyd Jones.
Well, I'm very sorry. It was emailed through, but basically there is a common law power, according to the case of Hall, to admit trial transcripts, but it's obviously different from the section 66. I will come to it, if I can, I'll come to it in
So
due
does
course.
that knock out the section 66 point?
Well, not entirely, because it's a different basis.
I see.
And, my lady, I can say that in the meantime, over the weekend, we have discovered there's a decision of Lord Justice Asquith in a case called Barkway on the very point about whether giving evidence to a court is providing information to the shorthand writer. And he
Why
says,
does it matter, Mr. Fitzgerald? If it's admissible at common law, subject to your constitutionality point,
Yes,
why does it matter?
my lord, simply because it was then treated as an exhibit and handed
So
to the
what?
jury.
Oh,
Well,
that?
Yes, my lord, because it became a document in the case,
I see.
and therefore the presumption was that it would be handed to
So the only complaint is that the jury took it away with them?
my lord, yes.
Got it.
Yes,
Thank you.
but that followed from the section 16. My lord, it's a very short point.
I see. No, I understand.
I apologise
I understand
if
that.
I've unnecessarily prolonged it. But
No, I'm sure you haven't done that.
If I can then just summarise the position, our grounds of appeal are set out in the electronic bundle at page 3299. And the first ground, as the board knows, is whether Justice of Appeal Isaac should have recused himself from sitting on the appellant's appeal because he presided over the second trial and made a series of adverse rulings at that second trial on issues such as the doc identifications, the admissibility of the evidence of Marcy and Scott and whether it should be excluded, and on whether there was a case to answer. And we respectfully submit that in the light of that series of rulings, he should have recused himself because it would give rise to an appearance in the eyes of an informed and reasonable observer that there's a real risk that he'd be predisposed to rule against the same points on appeal. It's a very unusual situation. We accept that the test is fact-specific, but we say on the facts of this case, he should have recused himself because given his series of adverse rulings on very similar, if not identical points, it would give rise to an appearance of bias.
Yeah.
The second point, and it's set out at page 3299, is that the deposition of Marcy and Scott and the transcript of his evidence at the first trial should not have been admitted as evidence in the third trial because it resulted in serious unfairness and prejudice to the first appellant. And as my Lord Hughes has observed, the second aspect of it is that the transcripts should not have been provided to the jury when they retired. That resulted in our respectful submission in giving them a preponderant weight and disproportionate weight, which they shouldn't have had.
Were you not refused permission on that last point,
Well,
Mr. Fitzgerald?
My Lord, we weren't granted permission on it, but I don't know. But can It is all part of the overall unfairness we submit. It may also, as I've observed, it may matter whether Section 66 is in play. But, my lady, I don't know, we've searched for authority as to whether a 5-person board has the power to review a situation if in the fullness of the hearing something comes up. And it must, in our respectful submission, be within the inherent jurisdiction of the board to take another look at a point of that nature. It would be our respectful submission that whatever the board, as it were, never exhausts its jurisdiction, and in a case where it's closely allied to the point on which leave was granted.
If we really thought there was something seriously unfair, we would do something about it.
Thank you, my lady. That's our point. My lord, sorry, my lords and my lady, we will seek to persuade you that there is something seriously unfair about what happened, because...
Well, it's the overall picture that you're really aiming at, aren't you?
Your ladyship's absolutely right, that it's the overall unfairness, and that compounded it. And then the third point is that the trial judge wrongly permitted doc identification of the first appellant by John Campbell, and also there was misdirections about the significance of the ID parade in relation to John Campbell. The board will recall that the independent identification parade inspector expressly said that Campbell did not pick out the first appellant. And our respectful submission is the judge simply left it as an open question, and that was wrong. And once he has not been picked up at the ID parade, that remains a significant factor to whether there should be a doc identification. And we say that there was also a failure to give proper directions. And then the final point, my lady, is the new evidence point, which to some extent goes to the reliability of Marcion Scott. Just in very brief summary, Marcion Scott said repeatedly at the trial that he was a police officer at the time, that is to say, on March the 29th, 1999. There is evidence in form of the National Insurance Board records to show they record him as having the employer of the Bahamas government right up until February, right through every month for many years up until February. And then in March, his employer is recorded as being the Paradise Island employers, i.e. an independent. So it appears from that record, and it's certified now properly, that something happened at the end of February and before March. So we do respectfully submit that it was a perfectly justified request that has been made actually as far back as September 2016 of the prosecution. Tell us, was he employed by the police as he stated or not? And we have had...
A long time ago, you all signed up to the Statement of Facts and Issues, which says clearly at 2.1, he was employed with Paradise Security Services on the relevant date.
Well, yes, my lord, and I think perhaps...
Which is what he'd said in his deposition, isn't it?
No, my lord, no.
No?
No, my lord, can I just take you to that? Page...
No, don't worry. Do it in your own time. Otherwise, we shall anticipate all these points.
Yes, all right. Well, my lord, he expressly says, page 25, where were you employed on 29? I was employed by the Royal Bahamas Police, for presently attached to the CID, page 27.
All right.
And he says, I can give you 4 times where he says that at the time of the offence, he was employed there, that he was off duty, but nonetheless on duty in the sense that he was interviewing an informant.
Right.
And so we say he repeatedly said it, and it would appear to be untrue. And if untrue, one wonders why he didn't tell the truth. And we also wonder why, with great respect, the state can't tell us what the answer to a simple question is.
Mr. Fitzgerald, at page 580, in the summing up in the third trial, the judge said that in his deposition, Marcion Scott stated he was employed at Paradise Security Services.
Well, that's just wrong. I mean, he was employed by Paradise Securities. He said that he was presently, that's to say at the time he was giving evidence, employed by Paradise Securities.
No, he says it, well, the judge says,
Well,
in the deposition of Marsh and Scott, he says he was employed at Paradise Security Services on Paradise Island on March the 29th, 1999.
My lord, can I just take you to the...
Yes,
Could we perhaps take everything in order
Yes,
and
sorry.
not pursue each of these?
I'm so sorry,
It-
my lady. I apologise. My lady, I quite...
It will be much more efficient
Yes.
if you deal with each of your points in turn, and we then put to you whatever we have to say about each of them.
My lady, absolutely. Well, my lady, you have our summaries of the the prosecution case and the defence case, and so can I just deal firstly with the bias point? The court has, in the statement of facts and issues at page 3269, the rulings that were made by Mr. Justice Isaacs in the second trial, and the court can see at page 3269, he permitted John Campbell to make doc identification of all three appellants. He ruled section 168 of the Criminal Procedure Code was constitutional and found the deposition to be admissible. He declined to exercise his discretion under section 178(1) of the Evidence Act to exclude the deposition. He ruled that the first appellant's interview was admissible and declined to edit that interview to exclude reference to the second appellant. And he rejected no case submissions in relation to each of the three appellants. My lady, in our reply, we have further developed the point, and if I could just take you to our reply at page 3 to summarise, those are the rulings
Do we
compared...
have this electronically?
Yes, I think you do. Yes, it has been served electronically. It was served a fortnight ago electronically.
How many documents have we got electronically?
My lady, you have that reply. It was served a fortnight ago electronically. It was served electronically. Do we have a copy?
Well, when you say served electronically, Mr. Fitzgerald, what actually happened is you sent it by email. So we've...
Not the same.
A hard copy was served.
But we've got a hard copy as well.
Yes. Well, my lady, did you...
I'm sure I've got a hard copy, but I like to have all the documents
Yes. Well,
electronically in one document,
Yes. Well,
not in 6 documents across the top here, because that's impossible to... They're not sufficiently labelled for me to tell which is which.
I do apologise.
This is not the way to run an appeal.
Well, my lady, the reply couldn't be integrated into the electronic bundle, and that's why the court has it. Does my lady have it?
No,
we have a
I
copy.
don't have it.
My lady, we have a copy.
Looks like this.
No, I've got a third appellant's reply.
Well, we
I'm
served
not
our
sure
substance.
what it was.
We served it some time ago. I was told that it would be on the electronic.
So we always have something like this that goes on, Mr. Fitzgerald.
Well,
we always have something like this,
yeah,
so don't let it put you off.
If it's
My lady, Lord Mance told me on the last occasion that it was perfectly permissible to put in a short reply, and therefore, but not a speaking note. That's why I put in a short reply, but not a speaking note. I apologise but that I was following his, I was following his express
Of
instructions.
course, you didn't know who you were going to be encountering this time.
Well, I think I apologise, my lady.
That was rather more about the duplication of the speaking note, I think, Mr. Fitzgerald. If it's any help to anybody else, your reply I have as a PDF labelled 18.06.22, final first appellant's reply, brackets, without something.
No, I seem to have a different version of it.
Yes.
Does your ladyship now see it then? At 2.2, we make the point that he ruled up section 168 was constitutional and found Scott's deposition at the preliminary inquiry to be admissible as evidence at the second trial. He then declined to exercise his discretion under section 178 to exclude Scott's deposition on grounds of unfairness and the fact that it incorporated a prejudicial doc identification. but then the constitutionality and fairness of admitting Scott's deposition was the subject of ground 3 of the first appellant's grounds of appeal and ground 9 of the second appellant's grounds before the Court of Appeal. And one can see that from volume 3, page 830. He permitted John Campbell to make a dock identification. He did so in peremptory terms. My lady, I give the court the reference, it's pages 314 to 3142. Effectively, he didn't even require, the prosecution began to justify it, and he said, I don't even need to hear you. Defence counsel had said, this is an outrage, and he was just told, I've already made my ruling. So it was in very peremptory terms that he made the ruling on John Campbell's dock identification being permissible. And yet the permissibility of the dock identification was one of the matters urged by counsel for the first appellant before the Court of Appeal. Can I just give you the references? It's at paragraph 20 and paragraph 40 of the Court of Appeal's judgment, and you have the reference to paragraph 20 is at 825. Fourthly, he ruled that the first appellant's interview was admissible and declined to edit that interview to exclude reference to the third appellant. The admissibility of the record of interview was ground 4 of the first appellant's grounds of appeal, and the failure to edit it was ground 6 of the third appellant's grounds of appeal. And then he rejected the no-case submissions. Yet this is precisely the same point as was taken again on appeal. It's ground 1 by the first appellant, and he made the same ruling in respect of the third appellant. And this point was also taken before the Court of Appeal. And so we respectfully submit that there is an identity of rulings to the issues on appeal. Of course, they're not absolutely identical, but there is such substantial overlap that we say a well-informed and reasonable observer would say he has already decided those issues adversely, having heard argument from the very counsel in this case, on behalf of the very appellants in this case, on very similar evidence and very similar points of law. And we say, if you take all that together, because it involved mixed questions of mixed fact and law, it involved questions of the exercise of discretion, questions of fairness, and questions of law. And he'd ruled on all of them adversely to the first appellant and the other appellants at that second trial. Now, what we respectfully submit, if I can just very shortly take the points. Firstly, can I just make these short propositions rather than taking you through the case, my lady? The concept of an objective appearance of bias includes a clear indication of a prematurely closed mind or of predetermination. My lady, we've cited the case of Ott Critty to that effect. It's volume 2 of the authorities, tab 45 at paragraph 1. So if I can just go to volume 2, tab 45.
Where will I find this in your case?
It's set out in the case, my lady, at, if you'll just give me 1 minute. So we deal with the point at part 6, and we set out the Ott Critty case at 6.13, page 3310, my lady.
Thank you very much.
So so it's as it were as a subcategory of bias is that he might in some way have prejudged the case, as your ladyship will see the quote there. So, as my learned friend rightly points out, this isn't a case where we're saying financial interest or some personal motive, but it's a well-recognised form of bias that there is a risk of prejudgment because of prior judicial conduct.
Well, it's usually a prior ruling by the judge in the same case, isn't it?
Yeah, absolutely, my lord. That's right, and that's many of the cases we cited, for example, Ray Kay and Rio and Amjad, are ones where the judge, in the same case, has expressed himself in strong terms on an issue at an early stage. And there, of course, the court says, well, there is a public interest in continuity of judicial personality. In other words, there's a strong public interest that the judge who hears the interlocutory matters, I think in the Ablyazov case this arose, should continue to hear the matters. And the fact that he may make an adverse ruling is not of itself enough. Here there was no necessity that the same judge who'd made this series of adverse rulings should sit on appeal.
How many appellate judges are there?
There are, I know there are at least 5 because I've sat, I've not.
You've sat
I wasn't sitting. I've appeared, in the case of Bowe and Davis, for example, there was a five-person panel chaired by Dame Sawyer, and the Chief Justice is an ex officio member. I mean, so there could be as many as 6.
Well, yes, hang on. They might have convened a 5-person panel. There are actually very few of them, I think, Mr. Fitzgerald, aren't there?
Well,
one of them would have been in the same position as Mr. Justice Isaacs.
Yes, but my Lord, there was no suggestion of necessity in this case in the ruling.
Well, no. When we get to it, we shall see that nobody managed to explain to the Court of Appeal that there was any identity of issues between the rulings that Mr. Justice Isaacs had made and the grounds of appeal.
Well,
but never mind that for the moment. The numbers might be a practical issue.
Well, my Lord, the Chief Justice is in the Constitution, and in the Court of Appeal Act.
If available, yes, I see.
Yes. But put it this way, what we know is that the panel that was originally constituted did not include Justice of Appeal Isaacs, and they were completely taken by surprise on the morning, and he himself observes that in the judgment.
Yes.
So to say that they hadn't, as it were, got their tackle in order may be somewhat unjust. They were taken by surprise by his appearance.
Right.
They made the objection. My Lord, I'm really coming on to this point. So the test is whether a reasonable and well-informed observer would apprehend a real risk of bias by way of predetermination or predisposition. So then the third point we make is, well, what would the well-informed observer need to know? The well-informed observer would inform himself, we respectfully submit, of the issues the judge had already determined in his capacity as a trial judge in the second trial, and as to whether the same issues of mixed fact and law, fairness and exercise of judicial discretion would arise in the appeal. In other words, to sit there, to simply say it's for you to prove your case of bias. The judge sat in the second appeal. We respectfully submit that the notion that he'd simply forgotten that fact when this was a very much publicised case, so much publicised that there was a successful motion for a declaration that the pre-trial publicity had caused the risk to fair trial by Justice Jones. There was a declaration on that issue. Now, what we respectfully submit is that, of course, he would remember the case or inevitably recall the case once he'd embarked on the hearing. Your Lordships will know the case, we all have the experience where you were in that case, I don't remember it. At the moment somebody tells you the facts, it all floods back. But what I'm respectfully submitting is, it was the judge's job, knowing that he sat on that second trial, to inquire, well, here are your grounds. Are you saying that the issues are the same? And because the well-informed and reasonable observer informs himself, and the judge who's got to apply that test informs. In any event, I am told that they did say, well, you made a number of rulings, but they were taken by surprise because he appeared on that day. Now, the fourth point is we respectfully submit that the fact that Justice of Appeal Isaacs was about to determine the very same issues he had already determined adversely to the appellants on very similar facts was highly relevant. Now, we've cited in the case, my lady, a number of authorities. Can I just highlight some of them? They're set out from pages 3310 onwards, and I referred to Amjad, where Lord Justice Sedley said that bias by way of prior determination was a subheading of general bias. I've given the court the references to Reg K and Reg Q.
Have you given us the references in the authorities?
Yes, my lady,
Yeah,
they're all set out.
documents.
Yes.
Well, my version of your case doesn't have cross-references at all.
Well, REQ is volume 3, tab 57. This is, my lady, I'm in the case. Is your ladyship on the case?
This is your case.
Well, at page 3310, our case, not of our case. The appearance, my text reads, the appearance of bias by way of predetermination or prejudgment is a recognised ground for accusal.
Paragraph 614.
Yes, my lord.
Yes, it hasn't got the cross-references in it, but don't...
Well,
you give them to
I can give you, yes. They have been added, and I'm sorry.
Well, they may have been added for you, but they've not been added for us, Mr. Fitzgerald.
Well, my lady, I had understood, and that had been provided, because I got page 3310 at the bottom.
We don't have that either.
No. But that was settled at least a month ago. It was settled at least a month ago.
Well, never mind.
Okay.
It just
I'm
means that you're going to have to
Yes,
give
I'm so
us
sorry, my lady.
both the tab numbers and the electronic
Yes, I'm so
page
sorry.
numbers.
Okay. 3310,
Thank you.
Amjad, volume 1, tab 18, 3782, REK, volume 3, tab 56, REQ, volume 3, tab 57, and we've set out Amjad there. At 6.15, page 3311, we cite the case of Hauschild, and we rely on that, where the judge had determined the question of refusal of bail on grounds that there was strong presumption of guilt, then it was held that the judge should not go on to hear the full matter. And that's the European Court's decision. We've given your ladyship in the court paragraphs 49.
Well, you probably don't need to go that far, Mr. Fitzgerald, but I mean, if that were the general rule, it would be impossible for any trial judge to make a decision about remand.
Yes. No. What Hauschild says is that in the normal case it's fine, but in that particular case, in Hauschild, the judge had made repeated findings that there was a strong presumption of guilt. He'd gone under a particular section.
Right.
So the strong presumption of guilt.
Yeah, well, you don't need to go that far, do you?
No, absolutely. Mitchell and George's, which is Authorities, Volume 2, Tab 42, page 4244.
242, yeah.
Yes. 242. That is the case where, in an interim report, the judge had expressed strong views in that interim report, and as a result, the board found that it would be inappropriate for the judge to go on to consider the full inquiry. We have Mitchell and George's at volume 2, tab 42, and it's the language of, if I can just give the court page 4244, it says there, the problem here was that, as the Court of Appeal put it, the Commissioner's interim report was replete with strong and colourful language, and it was true the Commissioner, quote, used the decisive language of a concluded finding. So using the decisive language of a concluded finding. And then, as a result, in the opinion of the board, the fair-minded observer would conclude there was a real possibility the respondent had made up his mind that the appellant was at the heart of the wrongdoing, which led to the project and its collapse. And over the page at paragraph 44, the extracts from the interim report set out above strongly support the conclusion that, having regard to the context and all the surrounding circumstances, the fair-minded observer would conclude there's a real possibility the respondent had made up his mind by the date of the interim report. So it's premature conclusion. The case of Al-Arkan is set out in the case at 6.22, and can I just take court to that? It's at page 3314 in the electronic bundle, and the citation from Al-Arkan we respectfully rely on. it is one thing for the fair-minded and impartial observer to have faith that a judge will reassess his views with an open mind when presented with new evidence and argument. It is asking more of the observer's faith when similar evidence and arguments are presented to assess the same issues. So it's the same issues by the same counsel on roughly the same facts. Of course, each trial is different, but the facts are roughly the same, and the very similar arguments.
Have we actually got any cases of where the problem arises in relation to sitting as a component of a court of appeal?
No, my Lord, we have searched high and low, my Lord, and we say
there
because...
There may or may not be a reason for that.
Well, my Lord, that's our respectful submission, that the reason is that a judge would normally recognise that it was inappropriate. There is the decision of the Bahamas Court of Appeal that Justice Allen, as she then was, could continue to sit in the trial after her conviction had been upset by the Court of Appeal. But that's a different issue, because there's then been an intervening correction by a higher court saying you got it wrong, and it goes back. And in any event, they found that there wasn't an identity of issues.
Well, that happens all the time, doesn't it?
Yeah.
Appeals are allowed,
Yeah.
and the appellate court makes a decision whether to remit the case to the same judge or a different one.
My Lord, we say that this is a highly unusual situation. All we can do is to try to provide the board with a number of analogies and to try to extract from them some underlying principle. But we do say that all the authorities refer to the notion of where you've reached a concluded adverse finding on the same or similar issues. That is a highly relevant factor. And we say that the idea that they were provisional findings, which my learned friend puts forward, is with great respect incorrect. When he said, I admit this evidence, I reject the section 178 argument, I allow the doc identification, I reject the no case submissions, those were concluded adverse findings. There was nothing provisional about them. The judge had decided the issue, and when the very issues come back, should a doc identification be permitted? Well, I permitted it. Indeed, I didn't even bother to ask for argument on the issue. The prosecutor's there saying, can I justify this? No, you don't even need to address me. In it goes, is what happens. And we respectfully submit that then when he has to decide again in the Court of Appeal that self-same issue, should a doc identification by Campbell have been permitted, we respectfully submit that there was a real appearance of bias. Now, we do the Al-Hassan case we've cited, and that's in the case at 6.28. And in Al-Hassan, could I just take the court very shortly to that, because it has some similarities. There, the deputy governor, it was a prison adjudication. The deputy governor of the prison had been present when the governor had made an order that there should be squat searches of all the prisoners. Later on, the deputy governor presided over the disciplinary adjudication of the prisoner, where the prisoner ran the point. The order for a squat search was unlawful. And the House of Lords, as it then was, found that because he'd been involved in the history of the case, even tacitly present when the order had been given, but not protesting, the deputy governor should not have sat in adjudication. And there are some dicta which are of some help. At volume 3, tab 61, so at volume 3, tab 61, one sees Lord Brown dealing with the issue. So I hope I don't need to summarise the facts. It's page 4750 of the electronic bundle. I'm so sorry if I can, yes. So if we go back to page 4747, there is a review of various authorities, Lawal, Davidson, Procula, which we do rely and then McGonnell, where there'd been some prior commitment to the issue of law or fact. In Procula, there'd been some prior commitment in their status as members of the Conseil d'État to the non-retrospectivity issue, which they then had to decide again as judges. And Lord Brown found the Procula case helpful. He says at paragraph 37, page 4749, I return therefore against the background of the relevant case law to the critical question, how would a fair-minded observer regard these appellants' adjudications? Would he think it a real possibility that Mr. Coppell, having been present when the Scott search order was confirmed by the Governor, would be predisposed thereafter to find it lawful? Would he, in the language of the Strasbourg court in Procula, doubt, however slight its justification, about Mr. Coppell's impartiality, have legitimate grounds for fearing that Mr. Coppell may have been influenced by his prior participation in the decision-making process? And one sees at the bottom of page 701H, when thereafter the order was disobeyed and he had to rule upon its lawfulness, a fair-minded observer could all too easily think him predisposed to find it lawful. And then at page 4740 of the e-bundle, paragraph 41, from all this it follows that to have avoided the appearance of bias, Mr. Coppell would either have to make plain that the adjudication himself actually been present, or have invited the consent of the prisoner. And that's at paragraph 41, page 4750. And then having found that there was...
Sorry, it would have been enough if he'd made it plain that he'd been there, would it?
Well, and sought the prisoner's consent. To
I see.
Yeah, so if you... for example, if Justice of Appeal Isaacs had said, of course, I have to alert you that I made... You're probably all aware of it. Do you have any problem with me? And the answer had been no, then by analogy that would have been okay. But then at paragraph 43, Lord Brown says, it cannot be permitted to stand. And my lady and my lords, there is the answer to the point. Well, you would have lost anyway. In paragraph 44, only recently in Miller and Dixon, Lord Bingham took the same view with regard to a number of decisions where there's nothing to suggest that the outcome of any of these cases would have been different had the relevant stages of the process been conducted before permanent instead of temporary sheriffs. There is no reason to doubt that the conduct of all the temporary sheriffs involved was impeccable, but it is in my view clear from the authority that the right of the accused in criminal proceedings to be tried by an independent and impartial tribunal is one which, unless validly waived, cannot be compromised or eroded. So it is my learned friend puts it in a rather subtle way. He says the judgment, the rulings were not surprising, i.e. he's suggesting inevitable. Both Lord Brown in Al Hassan and Lord Bingham in the Miller and Dixon case make it clear that that is not a proper approach, but in any event, we don't accept that they were inevitable. For example, the issue of the dock identification, Campbell, we say, there is a very powerful argument, which we're about to advance to the board, that it shouldn't have been permitted. And the unfairness argument, setting aside the constitutionality, but just the unfairness argument in the relation to Martin Scott is also, we say, submit a powerful one. So those are our points. Now, Mr. Knox actually, in his case, quotes at page 3219, 3517.
Could I have the paragraph number?
Yes, it's paragraph 29.
Thank you very much.
So he sets out a quote from the case of Zuma, where Lord Justice Floyd makes a holding on the question of bias. The court will see that my learned friend has underlined two passages. The fair-minded and informed observer does not assume that because a judge has taken an adverse view of a previous application or applications, he or she will have prejudged or will not deal fairly with all future applications by the same applicant. They're different future applications. But then look at the bit that he underlines at the bottom. The position might well be different if in the past the judge has expressed a final concluded view on the same issue. Well, that's exactly our point. The judge had made a final concluded view on, is there a case to answer? Should the doc identification go in? And that Lord Justice Floyd, who my learned friend relies on, is saying that's very different.
Well, actually, in the same trial, or the same set of proceedings, you may very well have the same issue come up twice, mayn't you?
Yeah. And my
You
Lord,
may well have decided it
yes,
in the past.
and my Lord,
But your point is that appeals are different.
yes, my Lord, and I won't take you to all the cases, but the cases, and I know my Lord Sumption will know from the Abliazov case, that what the courts say is, well, sometimes in order to have the same trial judge conducting the case management hearing, the interlocutory hearings, the contempt hearings, you've got to have the same judge. There's an interest in that. But there was a complete, well, we say there was a complete choice here. He didn't have to sit.
Presumably, if at the conclusion of the second trial, Mr. Justice Isaacs had said, very well, we'll start again next week. We'll impanel a new jury.
Yes.
We'll start again next week. He would have had to have gone through all the same applications on very similar evidence, yes, in all likelihood.
Yes.
But your point is that while there could be no objection to that, an appeal is different.
No. And yes, my Lord, with just this codicil to my concession on that, yes, is of course if he'd expressed himself in inflammatory or if he'd done more, what Lord Bingham says in one of the cases is if what you do is just the normal exercise of your judicial functions, you can't then say to that judge, you're exercising your normal judicial function that you ruled against me, so please don't carry on ruling. But we do say it's completely different if you're then sitting on appeal, where it's not necessary, and where you're passing judgment on a submission that your successor judge had made an error in identical terms to what you had decided in the earlier case. And it's not just one, it's a whole series. No. And they're not issues just of law, as has been said, or was said by the Court of Appeal. They're issues of mixed fact and law. They're issues of fairness and discretion. Can I just then, that perhaps there's two other cases I should show the board before concluding. The case of Livesey, the Australian case, unfortunately that is not referred to in our case, but though we did put it in the bundle, and it's volume 2, tab 38.
Tab
38. So this is the case which is of some assistance, we respectfully submit. So volume 2, tab 38, page 4126 to 4128. That was where the judges were sitting on a disciplinary hearing, having made adverse statements about the individual in an earlier proceeding, separate but the same individual. And so if I can take the board to 4126. Yes. Perhaps if right at the bottom, so was there, right at the bottom of 4126, was there an appearance of bias or prejudgment submitted on behalf of the association that a reasonable observer would be aware of the ability of any judge of the Court of Appeal to put from his mind evidence heard and findings made in a previous case, to decide the case at bar impartially and fairly on the evidence led in that particular case. As we've already indicated, however, we do not consider that a case such as the present is to be resolved by reference to the ability of the members of a particular court or the public confidence in the integrity of the judiciary. What is an issue in the present case is the appearance and not the actuality of bias by reason of prejudgment. The reasonable observer is to be presumed to approach the matter on the basis that ordinarily a judge will so act as to ensure both the appearance and substance of fairness and impartiality. But the reasonable observer is not presumed to reject the possibility of prejudgment or bias, that's to say by a judge, nor is the reasonable observer presumed to have any personal knowledge of the character or ability of the members of the relevant court. And then there's a citation from Hannam and from ex parte Topping. At the bottom of page 4127, necessity, and we say that doesn't apply here, and the extraordinary case, make it impossible to lay down an inflexible rule. Each case must be determined by reference to its particular circumstances. It is, however, apparent that in a case such as the present, where it is not suggested that there is any overriding considerations of necessity, special circumstances, or consent, a fair-minded observer might entertain a reasonable apprehension of bias by reason of prejudgment if a judge sits to hear a case at first instance after he has in a previous case expressed clear views either about a question of fact, which constitutes a live issue, or about the question of the credit of a witness. And then it cites that the first full paragraph, a central issue in the main charge against the appellant is whether the money which Miss Bacon lodged as bail was her own money. Two of the three members of the court, which was hearing the proceedings as a court of first instance, had already held in a previous case that it plainly was not. Two members of the court lower down had in the previous case expressed a strong view she was a witness without credit. And then the question which arises is whether there be a reasonable apprehension of prejudgment, and they find that there would be. But I do rely on that, for one can't simply say, well, this is a judge, therefore they will act fairly and impartially, and any earlier determinations should not give rise to an appearance of bias. A predetermination of an issue of law can also justify recusal, because the Court of Appeal relied on the fact, well, there were findings of law, not fact. We don't accept that characterization. They were mixed law and fact and discretion. But the case of Proctor and Luxembourg, Volume 3, tab 51, at paragraphs 4, so can I take you to EB 4598 to 4599? And we've cited this in the case. But Proctor and Luxembourg, one can see at volume 3, tab 51. So if I get 4598. Seems to be volume. It's tab 51. Proctor and Luxembourg, yes, it's right at the start. Right at the start. You can see that the relevant ruling, there the judges who were hearing the matter had given an advisory opinion on the same issue in their capacity as members of the Conseil d'État, and one sees at 4598 in paragraph 41, two sentences in view of the opinions they had previously expressed, particularly in the letter sent by the President of the Conseil d'État to the Prime Minister, the members of the Judicial Committee could not have approached the question submitted to them, namely whether it was lawful to apply the ministerial orders retrospectively with a completely open mind. And then one sees the impartiality requirement dealt with at paragraphs 44 to 45. In the instant case at paragraph 45, bottom of 4598, Mr. Proctor had legitimate grounds for fearing that members of the Judicial Committee had felt bound by the opinion previously given. Now, we do say that indicates it's not just findings of fact, it extends to findings of law, and indeed, if one looks at Al-Hassan, the finding of the question there was an order to squash search lawful, which is a mixed question of law and fact. So it's not right to say, well, it's completely different if it's an issue of law, and in any event, it's not right to characterize these decisions as pure issues of law. My lady, the prosecution rely on the case of Sengupta, and they say that is authority for the principle that a judge who's decided an issue at an earlier stage can have an open mind at a later stage. Even a judge of appeal, who in that case had decided on the papers to refuse permission, Lord Justice Laws had refused permission to appeal on the papers, then he comes to review the same issue at the substantive hearing. There's an objection and there is a ruling. And can I just summarize the point I wish to make and then try and show you the Lord Justice Laws was saying there, when a judge refuses permission on the papers, he is making a necessarily provisional decision because he knows it's going to be reconsidered at a later stage, hearing oral argument at a full hearing. That's part of his ratio. And Lord Justice Keane, who gave a concurring judgment, very much stressed the fact that when a Lord Justice refuses permission on the papers and says, I think the judge got it right from what I've looked at, they are necessarily expressing a provisional view, knowing that it can be reconsidered by a full court at a later stage. There is no, and our point is, there's no such necessary provisionality in this case. The judge made his ruling in the earlier case, and he made it quite categorically. Now, so can I take the court, Sengupta, volume 3, tab 62, at page 4769, and one sees there, so the background being that Lord Justice Laws had refused leave on the papers and then was sitting on the full hearing. Paragraph 32, I accept there will be some circumstances where such a fear would certainly be reasonable. If a judge has presided at a first instance trial and roundly concluded on the facts that one of the parties lacks all merit, everyone would accept it would be unthinkable he should sit on that party's appeal. He has committed himself to a view of the facts which he himself had responsibility to decide. We do underline that. Effectively, we would say that although the language was not intemperate, although the adjudication on the admissibility of the doc identification was pretty peremptory, likewise, the judge here had committed himself to a view of the mixed law and facts which he had a responsibility to decide. But then one sees Lord Justice Laws goes on, the ordinary case is 4769, paragraph 35. The ordinary case is far from those instances. It's the kind that has happened here. The judge in question has not himself had to resolve the case's factual merits, has not expressed himself incontinently. All he has done is to conclude on the material before him the result arrived at in the court below was correct. And he has done so in the knowledge that at the option of the applicant, his view may be reconsidered at an oral hearing. In such cases, there are reasonable basis. So he stresses that it's going to be provisional and it's going to be reviewed. And that paragraph 36, absent special circumstances, a readiness to change one's mind upon some issue, whether upon new information or simply further reflection, and to change it from a previous is a capacity possessed by anyone prepared and able to engage with the issue on a reasonable, intelligent basis. We say yes, but subject to live see, that one doesn't have to expect judges to be superhuman. They are going to be influenced by their strong views on a case or clear views on a matter when the same issue arises on appeal. And then Lord Justice Keane is very much stronger, if I can put it that, on this point about provisionality. Lord Justice Keane, it's his judgment at paragraphs 43 to 48. So page 4772, just halfway down paragraph 43, it's clear that those decisions emphasise the need for objective impartiality as seen by an observer, so that justice may be seen to be done. And then at 44, what cases like House do bring out is the need to see whether a judge is in reality having to decide the same question on which he has previously reached a determination. Initially, it seemed to me that it could be argued with some force that was the situation that exists in the circumstances the court is having to address. Decision in Thoman and Switzerland could be explained on the basis that there the first trial was conducted in absentia, so the court had not heard the defendant's side of the case at that stage, whereas on the trial, the court would be hearing his evidence and would therefore be dealing with a new factual situation. Same could not be said where the single Lord Justice has considered on the papers the essential arguments being advanced on behalf of the appellant for permission to appeal. However, on further consideration, I've concluded the nature of the decision being made by the single Lord Justice at that stage is sufficiently different from that required on the hearing of the substantive appeal. When making a decision on the papers whether or not to grant permission, the single Lord Justice is well aware that though his decision may prove to be final, there exists the opportunity for the applicant to renew his application orally. And then he makes very important the point that he'd never heard oral argument, that the Lord Justice goes, well, that's the exact contrary of our case, where the oral argument had been deployed fully before the judge, to the extent that he allowed it on the doc identification, but it had been put. So we say there was nothing provisional about these rulings. That's the distinction of Sengupta. 2, there was no anticipation, well, at a later stage, when he made those rulings, there may be oral argument to the contrary. He'd heard oral argument from the very advocates on the very points and ruled against them. And so we say that on those grounds, Sengupta, which is, I respectfully submit, the high point of my learned friend's case in rebuttal, is distinguishable and, in fact, supports our case. And so, my lady, we do submit that this is our next point. It's clear the appellants were taken by surprise by the appearance of Justice of Appeal Isaacs. They did object. They did refer to him presiding and making adverse rulings. It's quite right that he says, well, he complains in his judgment that they'd not been provided with affidavit evidence. I can give you the reference. That's volume 3, page 810, paragraphs 33 to 34. But he was surely under a duty, we say, to inquire into the matter further himself. Moreover, the reasonable observer is deemed to make himself well informed on these issues. As to lapse of time, we say that's relied on by my learned friend. We say that that is not a good point. This was a memorable case. We've given you in the footnote in the case a reference, my lady, to the fact that this was a case which had enormous publicity, such enormous publicity that there was a successful motion that there'd been prejudice, but the judge said that I can cure the prejudice by my own directions, rather like the Hamza case, where it's finding that there has been prejudice, but it can be cured by clear judicial directions. And as to the argument, well, the same result will be reached anyway, we have made our submissions in the reply. It's not a relevant consideration. In any event, it is not and was not self-evident that the same result would be reached. And finally, in our case at 6.24, we've made the point that if there is any doubt, the judge should recuse themselves. I'm so sorry, we put the wrong reference. It's at 3315, the Otkriti case. It should be at paragraph 19 of the Otkriti case, and it's in the electronic bundle at 4363. And it's a citation from Lord Bingham in the case of Loca bail. So if I can take the court very shortly, volume 2, tab 45. Paragraph 19, it's electronic page 4363 to 4364, the quotation from the judgment of Lord Bingham in Loca bail, and one sees the penultimate sentence on page 4364, but if in any case there is real ground for doubt, that doubt should be resolved in favour of a recusal. Now, on the contrary, the Court of Appeal in this case, and we've set out our criticisms of their approach in the case, said the burden's on you, we should be very careful not to recuse ourselves. Judges should be careful.
Can we just look at what they did say?
Yes, my lord, yes.
Because I take your point, of course, but 803, I suspect, is probably the best place. Look, 803, 804.
Yes, my lord. Yes.
And I'm looking not so much in the judgment of Justice Isaacs as in the judgment of Mr. Justice Conte, I think
Yes.
it is.
Yes, Justice Conte, yes.
Yes.
So page 820, my lord?
No,
Oh.
804.
Oh, 804, sorry, yes.
Paragraph 17, effectively.
Yes. Yes. So, yes, just taking it, he might have made some rulings on law. The court has our submissions. They weren't just rulings on law. The slate, as it were, was wiped clean. Those rulings may well not be an issue in this appeal. Well, if they'd inquired, they would have found that those rulings were an issue in the appeal, or at least many of them were. Further, even if they were to feature in the appeal, will not be sitting alone. Well, that's no good. The fact that you're sitting with two other judges, you want three unbiased judges, not two unbiased judges and one where there's an appearance of bias.
Yes.
Thirdly, it has been some 7 years since Isaacs presided. this length of time should be sufficient to assuage any apprehension of bias. We respectfully submit, it, of course, in a jury case, you might say the lapse of time is an issue, but here, I make the point again, memorable, famous case. The idea that he would have forgotten what he ruled, or that it wouldn't come back very swiftly, is, with great respect, misguided.
Well, it may well have come back swiftly, but it's quite apparent that at the time that Mr. Justice Conte was writing this, it hadn't. Otherwise, he couldn't have said that.
Well, Mr. Justice Conte, of course, is
Yes, I know, but you can't. This is a reserved judgment, isn't it?
Yeah, it is, my lord. Yes. No, it's
Come on. So it's fairly clear that at least at that stage, no one had identified that the issues in the appeal may well be those on which a view had already been expressed.
Well,
now, I understand your point that they that may have been taken by surprise, which wasn't apparent before. But,
yes.
and I equally understand the point that it doesn't answer the question what should happen as the argument progresses and it becomes clearer what's in issue.
Yes.
But anyway, that's what he said. There's no reason to doubt it, is there?
Well, to doubt that he couldn't remember, I respectfully put I mean, my lord, I don't want to be disrespectful in any way. I simply submit that one would not forget that one had sat on this case. To remember the details of the exact rulings,
Quite.
That really is my point, my lord, that you've got to make an inquiry into that once. If, as it were, you arrive on the day unexpectedly to the appellants, and they say you made adverse rulings in the earlier thing, we're not comfortable, and our client's not comfortable with you sitting again, you don't say, well, the burden's on you. You say, well, let's have a look at it. Let's have a look at the grounds of appeal, and let's have a look at the rulings I made, and tell me whether there is an identity, and tell me whether because I mean, Mr. Ducil and his fellow advocates were completely taken by surprise. Mr. Justice Isaacs does actually refer to that, because he says, yes, paragraph 33, page 810. Further, no evidence was filed via an affidavit. This failure may be excused by counsel being caught by surprise by my appearance on the panel. He hadn't been there before. However, none made an application. Well, perhaps they thought, and I respectfully submit, not unreasonably, well, that should be enough that you sat and made adverse rulings. But if there was a duty, if the well-informed observer has to inform themselves, surely the judge has an equal duty to assist in that process of informing oneself, because the judge, after all, was there. And so, my Lord, we respectfully submit, it is a very unusual situation, as my Lord Hughes observes it.
Does it perhaps look as if the enthusiasm for applications to recuse sometimes becomes marked in the Bahamas?
Well, my Lord, because there'd been an earlier one, yes.
Even
yes.
In this case, really.
Yes, my Lord. Well,
and some of us have met it many times before.
In relation to Bahamas. Well, my Lord, yes, but my Lord, can I just put it that? Can I put this?
Doesn't mean that
no, exactly.
It may not sometimes be right.
The fact that we've had all this before, and the last two times you were wrong doesn't mean on the third time you're not right. And I, my Lord, of course, I appreciate that there may be situations where it tries the patience of the judiciary if there are successive applications.
It can slip into judge shopping, can't it?
Well, but my Lord, I respectfully submit that this was well-founded.
All right.
In any event, the board gave leave, so clearly this isn't just, as it were, as my Lord observes, I don't think I've ever heard of a case where this has happened before. And I think I respectfully submit that the reason may be that a judge would just automatically say, well, it really isn't appropriate for me to sit on appeal when I have gone right up to summing up on this case. Moreover, let's remember that this judge had to discharge the jury because of allegations of jury tampering. One knows not what information he was provided with in relation to that, or what suspicions were aroused. In our respectful submission, it's just not appropriate in those circumstances for the judge, who's part of the history of the case and made a series of adverse rulings, to sit on appeal, and certainly not to do so without making scrupulous inquiry as to whether the issues are identical. And, my Lord, I say this with great respect to both Chief Justice Conte and Justice of Appeal Isaacs, but I do respectfully submit that if one applies the tests that one can derive from the authorities to this admittedly slightly novel situation, the answer is clear. And as Lord Bingham said in Loca Bail, if it's not clear, actually the burden should be on recusal rather than on, well, I'll soldier on. And I mean, my Lord, that's my respectful submission. My lady, those really conclude my submissions in relation to the bias issue.
And were we to rule in your favour, what would you wish us to do about it?
Well, my lady, can I put it this? I have instructions that the appellant would wish the board to go on because obviously he's waited a very long time to have these issues decided. However, can I just make these points in my duty to the court? I accept that the normal consequence of a successful argument that there should be a recusal is that the hearing is, as it were, void, and that's really al-Hassan, it cannot stand. I accept, secondly, that the board's constitutional jurisdiction is to hear appeals from the Court of Appeal rather than appeals from the Court of Appeal. Well, we have to almost, as it were, write it out, the Court of Appeal judgment, if my submissions are correct. And so, my lady, my only basis for inviting the board to continue nonetheless would be respectfully this, that it would be open to the board to say that we, the board, have all the powers that the Court of Appeal have. You didn't have a hearing before an impartial tribunal at the Court of Appeal level. We will now supply that defect by giving you a fair and full hearing on the issues raised at this stage. I admit that would involve, as it were, looking, almost treating as in brackets anything said by the Court of Appeal in their judgment, because
well, it would involve all three appellants agreeing to have only a single tier of appeal.
And
basically,
my lady,
that's your instructions.
Those are my instructions, my lady. I put them forward with some unease, but those are my instructions because of the problems.
You can understand the reason that
No,
we're asking because we want to know the answer.
No, of course, my lady.
To the question, but also it's relevant to whether we ask Mr. Knox to address this fundamental issue before we get on with the rest of the appeal.
My lady, yes. And can I just say this? I accept that some of the points that we take in this appeal are more typically points taken before the court of, for example, the new evidence point.
This is true.
I mean, I don't want to get into the merits of it, but I typically, and perhaps even the point about the transcripts, because it doesn't appear to have been taken below. My lady, so therefore, those are my instructions, but I accept that it's really in, and the appellant does wish to have a final determination after all this time, but I accept that there are difficulties juristically in advancing that.
Are there also practical difficulties, Mr. Fitzgerald? I just don't know. Supposing we were with you on this, supposing that the case was accordingly remitted to the Bahamas Court of Appeal, is there anybody left?
Yes, my lord. Yes, because
Well, the three judges who sat on this occasion couldn't sit. Neither could actually, she's
No.
retired now, hasn't she, the former
well,
president?
the Chief Justice Conte is retired too.
And he has to.
My lord, I'm sure a quorum could. My lord, I know the board has intimate knowledge of Bahamas because the board sometimes sits there, but certainly, as I understand it, the Crown are actually saying that the proper course would be to remit.
Yes, it would.
Yes. So it must assume that there is a court
Yes.
available for it to be remitted
Yes.
to.
Well, as I say, certainly in the case of Bow, which is reported, it was a 5-judge court, and they weren't using the Chief Justice, as it were, get out of jail option for the six member. I'm sorry, I don't mean to be the additional member.
I had better ask Mr. Thomas and Mr. Cooper what their clients' views on this is.
On behalf of Mr. Davies, the second appellant, I have to adopt the same position that Mr. Fitzgerald has adopted. I acknowledge the difficulties in inviting this court to continue. Those are my instructions. I also acknowledge, particularly perhaps in the case of the second appellant, that the matters on which I, in due course, would be addressing the board may again be something that I can put it the same way as Mr. Fitzgerald may be seen as matters that might more properly be seen as matters before the Court of Appeal. And I also have to acknowledge what has been said before the board on a number of occasions, in that the local court should be resolving substantive matters where possible. So I hope, again, in the same way Mr. Fitzgerald has struggled to balance my duty to the court with what is the proper submission with what is my instructions.
Well, thank you very much indeed, Mr. Thomas. Thank you. Mr. Cooper.
Yes, my lady, my lords. On behalf of Mr. Evans, my instructions are clear that he does wish this court to reach a determination on the merits of his appeal in light of the extensive delay that precedes this hearing, and in light of the real injustice on the facts of his case, which is self-evident from the dissenting judgment of the Court of Appeal. Yes. But I too recognise the restrictions within which this board must operate.
Well, you've all been incredibly proper. No, not incredibly proper. Believably proper. Credibly proper in your submissions. We'll just retire for a moment or two to decide. Mr. Knox, we have decided that we would like to hear you on this point before we then decide what to do next.
Answer the bias point in full.
Yes, in full. Including what you suggest should be done were we to be with the appellant's case on this.
Can I leave that till the end?
I should perhaps ask whether, forgive me, Mr. Knox, I should ask whether Mr. Thomas or Mr. Cooper have anything they would like to add to Mr. Fitzgerald's submissions on this matter.
My lady, I did have one or two
right.
supplementary
Well, let's hear those
points, if I may, and just briefly, because obviously the facts of Mr. Evans' case are markedly different from yes. the first two appellants. And the first broad point I just wish to emphasise briefly is that Mr. Justice Isaac heard the same evidence at the second trial of this appellant, so would inevitably have found it difficult not to be influenced by his assessment of the evidence that he considered over quite so many sittings, such a protracted trial at first instance. And it would have been difficult in my submission for him to clear his mind of all of that evidence and the submissions he had already rejected, and to focus only on the evidence from the same witnesses from the third trial that postdated his sit-in at first instance. And I would simply submit that's not an easy mental task to perform, even with the best intentions. And my next point is that Mr. Justice Isaacs had already taken a clear position and ruled on precisely the same issues that he did come to determine afresh. And you have those references from the Statement of Facts and Issues. The key points are the central ground of appeal on behalf of Mr. Evans, namely the permissibility of the doc identification of Mr. Campbell. And he made a very stark ruling in relation to that, which is evident from his reasons on the no-case submission, which I'll take you to in just a moment. So I do submit there was a real risk of prejudice from the trial judge mixing up the evidence he heard from the trial that he presided over with the evidence from the third trial that he was considering on transcripts. And so I've mentioned he addressed the issue of the permissibility of the doc identification and the status of Campbell's ID evidence when rejecting the third appellant's no-case submission. The reference there is electronic bundle 3191, which is in the supplementary bundle. And it may just assist if I were to take you to that reference very briefly. It's 3191. It's a very short ruling on that single page. And could I invite the board to consider from line 18 of that page?
Beginning the witness Campbell purports.
Indeed, yes.
This is the ruling on no case.
Yes, this is the ruling from the trial of Mr. Justice Isaacs on Mr. Evans's no-case submission.
Yeah.
And one sees from this, well, perhaps I can just invite Lady My Lordships to briefly consider that.
Yes.
Yes, and so...
It says there's other evidence, basically.
Yes, and so the important point in my submission that after the judge recognises that Campbell's ID parade evidence is not supported by the independent parade inspector who had a primary obligation to record the evidence and ensure that the rules of the standing force were complied with, he went on to rule that Campbell was entitled to make a doc ID based solely on the value of the doc ID in and of itself, and that its evidential value would not be useless because there was other circumstantial evidence against evidence which it might support. He made a basic factual error by pointing to the evidence of Scott here at this juncture. Scott did not give evidence against Campbell, and that was an error repeated throughout the trials and the Court of Appeal ruling, and that he and Ambrose were being shot at as an example of that circumstantial evidence, but Scott simply provided no evidence against Evans. And then in holding that even if Campbell's evidence rises only to doc identification, that does not necessarily render such identification useless given the circumstantial evidence. I simply submit that is to misunderstand the value, the evidential status of a doc identification, and to presuppose that it has some, even if the underlying evidence which ought to justify it is entirely flawed and fails to support a doc ID, that it has some status in and of itself. And that can then go on to buttress circumstantial evidence. And these were the central issues.
Well, it's not circumstantial evidence, is it? It's the direct evidence of the two officers who say they chased the third defendant and that he had a gun and that they recovered it, or that somebody else recovered it in their presence. That's what they said.
Yes, and there are a number of different accounts of that
yes,
state.
But this is a no-case submission.
Indeed. I simply wish to highlight that this demonstrates how Mr. Justice Isaacs handled those central issues that he went on to determine on appeal. That's a simple point.
Right.
And I submit that it increases, that there must be a real risk of an increased likelihood that the same judge will maintain his previous trial ruling to the detriment of the appellant.
Thank you very much indeed. Was there anything you wanted to add, Mr. Thank you. Forgive me for not having invited you to address us on
Not
the issue. Now, Mr. Knox, that's given you a bit of breathing space.
Yes. Thank you. My lady, my lords, what I can summarise my submissions in this way. None of the rulings made by Mr. Justice Isaacs at the trial involved him in making any, what I would call, concluded finding of fact contrary to the appellants. Second, none of his rulings revealed any animus against the appellants by reason of passing comments or otherwise. Thirdly, there was nothing in the specific grounds of appeal to the Court of Appeal in the third trial which would have made a fair-minded observer think that Mr. Justice of Appeal Isaacs now could not bring a fair mind to the appeal. There were only, when you look at it, about 3 grounds which involved the same points as he had had to rule on when he had been the trial judge. I'll come to those in a moment. And fourthly, and perhaps most importantly, bearing in mind your Ladyship's and Lordship's comments this morning, I submit it does not make any difference that Mr. Justice of Isaacs was sitting as an appeal judge rather than simply sitting as a judge rehearing the trial after an abortive hearing. And I submit that really is the point in the case. Because if what had happened was there had been a retrial, let's say, with Mr. Justice Isaacs sitting as the retrial judge, having heard the first trial, having made these sorts of findings, no one would have batted an eyelid. So the real question is, does it matter that it so happens that 6 or 7 years later he now is the appellate judge? And the question in one sense for you is not so much the appearance of bias, but what is required for an appeal? Because that's really what my learned friend is saying. It makes all the difference that this is an appeal. And Mr. Justice of Appeal Isaacs was sitting as an appellate judge rather than just as a first instance judge rerunning the hearing. And I submit nothing turns on that. Or at least if anything does turn on it, not anything sufficient to make, to have required him to recuse himself. And we are talking about should he have recused himself, rather than would it have been wiser for him to recuse himself so as to avoid any trouble later.
The retrial judge has been told that his earlier rulings are wrong, and he must get on with it in the right way.
Well, he might not have been, of course. It might just be a retrial because the jury couldn't agree.
Yes, exactly.
But if he had been told by the Court of Appeal,
that might be very different. But in this case, I mean, it was simply an abortive trial. I don't think he even got to a summing up. I think I'm right in saying all that happened was that after the close of the evidence, there was a suggestion of jury tampering, and at that point the trial was aborted. So there was no question of any challenge to his rulings earlier on.
But can we tackle face on the difference? Because for my part at least, I see the force of that. Trial judges may have to start again halfway through. Well, may have to stop and start again fairly often, and may often have to have the same issue come up a second time on which they've already ruled. I understand that. I'm just wondering whether there is any difference in an appeal. Is perhaps the point of an appeal that you have 3 different people deciding it?
Well, you know what I'm going to say to that. 3 different people from the one who was the trial judge in the actual trial you're complaining about. But if there was a previous trial about which you have no specific complaint, because the whole thing was aborted in any event, and what is more, you were never convicted at the end of the day, I can see it might just have been different had that been the case. But if all we're talking about is a previous abortive trial, I submit the fair-minded observer, but that is the test, would simply say, well, I'm going to take a look at, as it were, what he did at the previous trial, and he'd say, well, it's completely unexceptionable, and no one would draw the inference of an appearance of bias. And that's my case. And I do want to take you to his rulings. I'm not going to read them all out, but to the material part. And they are entirely neutral, and they're not quite as bad as my learned friend Mr. Fitzgerald makes out. So I do submit it's important just to have a handle on what he did, because the fair-minded observer does look carefully at what he did in the first trial. But my submission is, if you're with me so far as say he could have had a retrial, he could have conducted a rehearing after an abortive trial, why does it make any difference that it's now in the Court of Appeal? That's the question. And I say it doesn't make any. There may be some other principle at play, which is not really one my learned friends alluded to. But What is it? My ladies, can I...
If he could have conducted a retrial, at least there would have been the facility for a fresh look at this on appeal.
Indeed, yes. That is right. But the test is still, in my submission, the same.
So was the look in this case by the Court of Appeal fresh?
Sorry, I missed that.
Was the look taken by the Court of Appeal to this case fresh?
In my submission, yes. One cannot, in my submission, there's nothing which my learned friend has drawn attention to in their main judgment from which one can draw the inference that they came to it with a closed mind. My learned friend hasn't taken it to the substantive judgment and said, look at the way they've dealt with my point about the admission of Scott's evidence. They've dealt with it summarily, as it were. They weren't taking it seriously. There's no criticism, actually, of the way, subject, of course, to the points which he might want to make later, but there's no criticism of the way that the Court of Appeal itself, in deciding this appeal, has behaved in a way which a fair-minded man would say was unreasonable or biased. Now, they've got their separate points that they came to the wrong conclusion, but that's not quite the point of my submission.
This case is put on the basis of apparent bias.
Apparent bias.
So it's not necessary to show that it's operating.
I accept that, but I would say, I make the same point in relation to apparent bias. A person looking at the Court of Appeal's judgment would not say to themselves, well, there's an appearance of bias here. You simply get back to the question one of the three members of the Court of Appeal had previously sat at the abortive trial. In one sense, one can test the proposition in this way. Supposing at the abortive trial, none of the rulings had been made at all, because it wasn't necessary for whatever reason. Would there be an objection then to Mr. Justice Isaacs sitting on the Court of Appeal? Now, I submit not.
Well, then you wouldn't be able to say that the same issue had been determined by him.
Exactly, but I'm just trying to test, if you see what I mean, the notion that the same judge can't sit in the Court of Appeal. If he hadn't made any rulings at all, I submit there couldn't be any complaint. So the question really is, given that he had to make some rulings, is there really ground for complaint? And therefore one does have to look at the rulings themselves to see whether they were such that a reasonable-minded man might say, oh, I think, he might unconsciously have predetermined these issues against you. And I submit not. And that one does have to look at what he said.
Is it right, Mr. Knox, that if he'd made no rulings at all and simply sat there like a pudding throughout the trial?
Well, no relevant rulings.
But is it right that he could then perfectly adequately sit on an appeal in the same case where what was going to be discussed was, for example, the summing up of the evidence?
Not in the same. No, he couldn't sit on an appeal against his own.
No. But I'm trying to get my mind around the notion that having tried an abortive trial,
yes,
and heard all the evidence and formed inevitably some view about some of the witnesses, although of course he's not deciding the facts.
Yes.
If you then get an appeal from the retrial, in which you're being asked to assess the summing up,
yes,
perfectly all right, is it?
In my submission, yes. There's no reason why he cannot bring a fair mind to it. After all, the evidence is not going to be identical. I accept materially it's going to be the same. Yeah. But I would submit there's no reason why he couldn't. Perfectly entitled to say, well, I've looked at that summing up. It's not the same as I would have given, or what I did give. But that's fair enough to me.
Unless something turned up which depended on some information that he'd gathered, which was particular. Yes, I see.
But in this case, all we know is he's made some rulings which don't actually involve any imputation at all against the specific appellants. I'll come to them in a moment. You look at the rulings, they're along the lines, there's contradictory evidence here, but there's a prima facie case. They are as anodyne as you're going to get, in my respectful submission. I accept the mere fact that it may be inevitable any court would come to the same conclusion. It's not a complete answer. But what I do submit as important is the nature of the rulings made in deciding whether a fair-minded person, properly informed, would say, oh, I don't think you can bring an impartial mind to this appeal. And that's the question.
Well, let's look at them, shall we?
Yes, the ruling, it's in the supplementary bundle one has to take. And the first ruling he makes, I'll take them chronologically if I may, is at page 3099. And one can pick it up at the foot of the page, I think. Mr. Cumberbatch, perhaps my learned friend had read 49.4 of the Jamaican Constitution. Now, this was the challenge to the Evidence Act, and the idea was that under the Constitution you have a right to face your accuser and so forth, and therefore the Evidence Act, in allowing for a dead witness to give evidence, was unconstitutional. And you can see how the judge picks it up at page 3100, I think. He then deals with the application as a matter of law, that's to say, was the Evidence Act unconstitutional? And he runs through the law until you get to page 3000, I think 107, or sorry, 3109. He runs through the arguments and he comes up with his conclusion at 3108. At the top of the page, and almost to the bottom of the page. So essentially, it's constitutional to allow for hearsay evidence to be given under statute, because it's always been regarded as constitutional common law anyway. He goes on to note over the page, 3110, the question as to how to exercise the discretion is still to be argued. So that, I think I'm right in saying, is the next ruling he makes, which begins at 3113. And he deals with this matter until you get to, I think I'm right in saying, at 3119. Sorry, 3116. Here he's talking about the deposition of Scott, not the transcript of evidence, but the deposition. And he says, I don't see anything wrong with this. 3116, lines 10 to 16. So the deposition goes in. And then the next ruling he makes is now, this time on the transcript of Scott's evidence. And you can see, one can pick it up at 3119, it goes over to 3120, and he says, I don't have jurisdiction to let this in. So in fact, it's a win for the appellants. So transcript of evidence goes out.
Sorry, where are you?
3120, at the top of the page. The first 10 lines or so. Now that, I mean, no one could possibly complain about.
That would have left the deposition without the cross-examination.
Yes, the deposition goes, well, minimum.
Without the trial cross-examination.
Yes. So there was some cross-examination even at the
preliminary hearing
inquiry stage, but you don't get the full transcript of evidence in. So he ruled that out at his trial. Then the next ruling begins at page 3121, and this is about, in relation to an application made by Evans, the third appellant, to edit out some of the things in Stubbs' statement, where basically Stubbs blamed, or seemed to blame, Evans. And here's his ruling on that. And you can pick it up at line 25 on 3121. And he goes on to say, I suppose it counts as a confession, rather reluctantly, but in the end he refuses to edit out the relevant bits. That in particular, 6 to 9 on page 3122. He goes on to note that the court will have to act fairly and so on and so forth, in its summing up by implication. Then I think the next one, which is the ruling in relation to Campbell's evidence, and what my learned friend characterises as the doc identification. Now this begins, Campbell's evidence begins at 3126. And one can pick it up at 3137. And at this point, he is being asked who was one of the people he's given a physical description of. And at 3137, you can see he refers to the gentleman who has had on the camouflage with fisherman hat. That's Davis, in fact. And so he says Davis was the man who first attacked the deceased. But he simply identifies him by reference to his clothes at that point. And then he goes on over the page to say who this was who he'd picked out at the identification parade at 3138. I pick out the first one. He was holding number 10, that's Davis. That was the gentleman who was wearing the camouflage fisherman hat in the West. And I pick out number 2, the one in the red shirt and the jeans pants. That's Evans. So he's giving evidence here that he's picked out 2 at the identification parade. Now, there is an issue as to whether he was right in saying that, but for present purposes, there he is. He is saying, this is what I did at the identification parade. And then that is, as it were, clarified and elaborated on the rest of page 3138. So the question then comes in relation to number 10, Davis, do you see this person here today? Yes, can you point him out? And so forth. That's Davis, and then dropping down to line 20. The one you picked out as number 2, he's sitting in the middle, long sleeve, blue checkered shirt, plaid shirt. Mr. Cumberbatch made the record reflect that witnesses identified accused Clinton Evans. So there's no objection to the identification of these 2 men. And he then continues at the bottom of 3138. Mr. Cumberbatch, that's the prosecutor on this, in this trial. Now, you said there was a person wearing a tannish-coloured shirt. Yes. That person wearing the tannish-coloured shirt prior to that day, did you know that person? Yes, sir. For about how long? It's about 8 years. Could you tell us how you get to know him? And then he goes on to say, I've known him from Yellow Elder. He's in fact talking at this point about Stubbs, but he hasn't yet named him as such. And this carries on over to page 3140. Giving more details. And then 3141, perhaps one can pick it up at 3140, the last line. Before the incident took place, I didn't see him for like a long period of time. Question that night, how long did you have him in your vision? About 20 minutes, coming from out of the club and so on, about 20 minutes. You told us about the lighting conditions. That person you saw, did you know that person's name? Answer, I know him. His nickname was Di, that's all I know. Now, this person you used to see about 2 to 3 times a month, you saw that night for 20 minutes or so, who you knew was Di at the time, do you see that person in court today? And then Mr. Ducille, Mr. Stubbs' advocate, gets up. My learned friend knows the rules. I don't think it's even necessary for me to have risen. This is an outrage. I say no more. To which the court simply replies, yes, Mr. Cumberbatch. Mr. Cumberbatch says, can I address the question in the absence of the jury? The court, it's not necessary, obliged. And then the court continues, in other words, Mr. Justice Isaac continues, I mean, it's not necessary to address me, Mr. Cumberbatch. The witness has indicated the basis upon which he recognised the individual. And then Mr. Cumberbatch obliged, Mr. Ducil, I've taken an objection in law. The court, I've ruled against it, Mr. Ducil. The witness is able to make the identification he's purporting to make. Now, my lords, my lady, my lords, it's important to note one thing about this trial. At this trial, what Campbell said was he picked out only 2 people at the identification parade. He does not allege at this trial that he'd picked out Campbell at the identification parade. So the identification he is here giving is not of someone he'd picked out at the parade, but Campbell was one of the other people there too. At the scene.
Evidence.
Sorry,
Stubbs.
Stubbs.
I beg your pardon,
Stubbs.
Stubbs.
Campbell's the witness. Stubbs is the person we're talking about.
I do find it difficult sometimes, my lady, but he's essentially saying, I know this bloke Dye.
Yeah.
I'd seen him around for some time before, and that's how the prosecution lays the ground for getting in the evidence that that's the bloke standing over there. He is not, but the important point is, Stubbs at this trial is not being mentioned as someone who was picked out at the identification parade. He's simply being mentioned as someone who Campbell knew anyway. And it's in that context that the judge says, I submit quite rightly, well, you've laid the ground for it. What is your objection? So my learned friend characterised this as a rather brutal, dismissive allowing of a block identification. It's nothing of the sort. And my lady, my lords, I don't know how much of the transcripts you've read, but it's fair to say there was an awful lot of interventions. And one can understand any judge at some point saying, look, I've got the point. Can't we just get on with it? So I do submit.
We never do that, Mr.
No, au contraire, my lady, of course not. But I do submit that this is, if you look, just taking these rulings so far, if you look at them and say, well, was this man unable to sit and decide the case impartially in the Court of Appeal, given the nature of the issues that were raised in the Court of Appeal, and 50 grounds of appeal, including 1 or 2 I'll come to in a minute, which touch on these rulings, I submit there's nothing special about this at all. And then finally you have the no case ruling, which begins at 3189 in the same bundle. And the judge, in my respect for Mr. Justice Isaac, goes through the evidence perfectly carefully, in neutral terms. He starts with evidence, so he deals with evidence from page 3189 to 3191 or 3192. But you'll note at 3191, halfway down the page, he says, in relation to Evans, that still, even if Campbell's evidence rises only to dock identification, that doesn't necessarily render such identification useless, given the circumstantial evidence against the accused, because obviously the point was being taken, it was a dock identification as a matter of argument. And then over the page, his conclusion in relation to Evans, 3192, it's the view of this court that on the totality of the evidence presented by the Crown, the prima facie case has been made out against the accused Evans on all 4 counts. My lady, my lords, you'll recall that there was attempted murder and 2 charges of possession of firearms against Evans. Then he deals with Davis in 3192 until you get to 3193. And you can pick up near the end of the page, penultimate paragraph. Judge concludes, the combined evidence of Marcy and Scott, John Campbell, suggests that Davis shot Jimmy Ambrose, shot Scott.
Sorry, I've missed that.
Sorry, 3193, my lord. At the foot of near the penultimate paragraph. Combined evidence of Scott and Campbell suggests that Davis shot Ambrose and shot at Scott. If Scott's evidence is believed in that latter regard, on the totality of the evidence, the prima facie case has been made out in respect of Davis, in respect of the 2 charges. And then he deals with Stubbs from 3193 down to 3195, and he recites the essence of the evidence against Stubbs. And then halfway down, 3195, having mentioned the evidence about the gun, the pistol that was found, but said to have been put under a Honda by Stubbs, halfway down, about line 12, the court recognises that there are inconsistencies in the prosecution's evidence, but it's of the view that they're not of sufficient gravity to render the evidence worthless or tenuous. court hasn't made mention of the autopsy findings of Dr. Kumar, noted that if that evidence is accepted, the jury can find that Ambrose met his death as a result of firearm injuries in the totality of the evidence presented by the Crown, the accused, against Stubbs. The court finds that the prima facie case sufficient to call upon, and so forth. And that's it. Now, I submit there's no suggestion here of any vituperation, no suggestion of any finding made against the accused. All the judge has done is look at the evidence in the no case submission and say, well, as any judge, I submit, would inevitably do, and say, well, it gives rise to a prima facie case. And there's no basis from that for saying that the judge won't be able to bring an impartial mind to the extent the same issue was raised 7 years later in relation to similar evidence. The judge has not expressed himself in such a way as to make him a reasonable man think, well, once there are different arguments in front of him, he's not going to bring a fair mind to it. I would accept it would be quite different, and obviously different, if the judge made concluded findings against witnesses. Or I must say I found for instance, supposing this had happened, supposing there had been a voir dire to allow in a confession or not, and the judge had said, yes, I'm satisfied that notwithstanding what the defendant says, he was not beaten. Then again, that would be a problem for the same judge sitting on the appeal. I would accept that. Because he would have made a concluded finding against a defendant to the effect that he was not to be believed. And he had made something up. I would accept that. But there's nothing here. This is simply saying, just looking at it as a cold lawyer, what am I worried about? What are you worried about with this?
If it's a jury trial,
yeah,
the trial the retrial on which the appeal comes to our hypothetical judge who's heard the first trial and has heard the voir dire,
yes,
why would it be even relevant that he disbelieved the defendant?
Well, if he was sitting on having a retrial?
No, if he's sitting on the appeal. I mean, if you're right, but if it's a jury trial, the impression that the judge has formed of the witness has got absolutely nothing to do with the grounds of appeal, has it?
No, not necessarily, but one could imagine, supposing the position was this, let's say at the abortive trial, Mr. Justice Isaacs had allowed in disputed confession, and more or less said, well, I don't believe a word of what Stubbs says, it can't be true.
Yeah.
And then let's say at the retrial, Stubbs wants to appeal specifically on the point that the confession was beaten out of him, or something to that effect. Then one can easily see he couldn't possibly decide that issue. He has already made a finding on a very similar point, which involves a direct imputation against Stubbs. And I would accept that if there was something said in any of these extracts or any of these rulings where one could draw the inference that the judge had taken a particular view of the case, which meant he couldn't bring a fair mind to it, I would accept he couldn't sit on the appeal. But I ask, as it were rhetorically, just by reference to the material I've taken you to, where does one get that inference from? Can I say this? One can well understand, just as a matter of what you might call humanity, one can understand how. Imagine Mr. Stubbs turns up and thinks, oh no, it's that judge who made a few rulings against me 7 years ago. One can always understand why an advocate sometimes doesn't want a particular judge on a hearing, on an appeal. And one can imagine a case where a judge has made a ruling on a point of law at first instance. He's then promoted to the Court of Appeal 5 years later. The same point of law comes up. Last person I want is him or her.
That's a problem that we do encounter from time to time.
Do you have to recuse yourself at that point? I submit not. Unless, if you've written about 10 articles on the same point, eventually people might think you're not going to bring a fair mind to it because the mind is closed. But on the whole, one has to bear in mind that the judges will obey their judicial oath.
That's Lockabell. That was one of the 4 cases in Lockabell.
Yes.
But that was a very extreme case.
That was a very extreme case, yes. But I submit we're not in this territory. And I do submit that the difficult point, if I can put it that way, but the one I doesn't make the difference in the end, is this was an appeal. Because I don't really apprehend my learned friend would be running this argument if Mr. Justice Isaacs had run a retrial. So it is all to do, does it make any difference that he's now sitting as an appellate court judge in relation to a retrial, to which my answer is, in principle, it certainly could, but then you have to look at the material to see if a reasonable person would be that bothered, and I submit the answer is no. Can I just go to the grounds themselves, just so we can, the grounds of appeal. It's core bundle 3. At 823. You can see at 823 the grounds on which Stubbs was appealing. I don't propose to go through all the argument, but just to show you the nature of the grounds being relied on by each of the appellants. And Stubbs is at paragraph 14, page 823. And really, it's the first and the third which involve the same issues as the judge himself had had to rely on or rule on, but they are put purely as matters of law. And I might say, in relation to ground 3, Mr. Justice Isaacs would have been notionally with the appellant in relation to deposition. Against the appellant on deposition, and with them on the transcript. Now, I'm just presupposing there's some sort of fear of bias, but it's not going to arise. But my main point is these are just 2 points of law. Turning to Davis, his grounds of appeal at page 840. And there are quite a few, but the only ones which are relevant to this issue, I think I'm right in saying, are 8 and 9 on page 841.
So Scott's evidence again.
Yes. Essentially, it's a section 6, it's a Scott's evidence.
They're both Scott's evidence.
Yes.
Law and discretion.
Yes, attack on law and attack on discretion. And then finally, Evans is at page 802. This must be a wrong reference. Maybe it's 862. Forgive me, my lady. I can tell I've got something wrong with Evans. 862. 862, yes. And there, I think...
There's another allegation of
Grounds
recusal.
5 and 7 is the non-editing point, and 7.
There's another recusal complaint in 4, isn't there?
Yes. Well, there had been a previous recusal. Mrs. Justice Allen had been made to recuse herself.
Yes, but this is a complaint that Mr. Justice Jones should have recused himself because someone had sent him a list of authorities by email.
Yes. Without being copied, I think because the other side weren't copied in at the time. But
I think you're making a point about that, my lord.
Now, I submit there's no reason why Mr. Justice of Appeal Isaacs could not have brought a fair and impartial mind to these issues. And a reasonable observer would not, on my submission, think he's not going to be able to do it. There are some cases I wouldn't mind just going to some of the authorities, because I do say what they seem to emphasise is that where a judge has obviously made a finding against a particular witness or party, then there is going to be an appearance of bias, or very likely to be. But it's rather different when all he's done is simply make a ruling to the effect of what you might call a neutral ruling, to the effect that a case can go ahead. And I submit we're in the former category rather than the latter.
Well, is that a convenient moment, Mr. Knox? Well, we'll adjourn now and look forward to hearing from you again at 2 o'clock.